Welcome to Notable Approvals. I am attorney Amanda Shaffer. Today, I actually have our first mass case notable approvals, or multiple cases I'm going to talk about that all fall into the same category. Before I get to our cases today, quick reminders: make sure to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video helpful or know someone who may find it helpful, go ahead and click that share button so that others can see this as well. And also, if you need representation, this is important too, I should mention this, our contact information on YouTube and on Facebook is scrolling across the bottom of the screen. On Instagram, if you go to our bio page, you can find all of our contact information there. We'd be happy to help. So today I actually have 6 different cases to talk about. I'm not going to go into crazy detail about each one of them because they're all still pending in one way, shape, or form. But they all have been recently dismissed from the immigration court. So no more removal or deportation proceedings for 6 different clients. Honestly, I think there's actually more recent ones that I'm slipping my memory. But definitely we're seeing this trend now ever since the Department of Homeland Security put out the Doyle memo. They've been coming faster and faster. So really exciting to talk about all these dismissals because it definitely takes a lot of pressure off the clients. And if they're eligible, they can get a travel document. So let's talk about not too many details, but a little bit of details so that the audience, the purpose is to help you understand what types of cases are being dismissed. And some of these cases were also reopened as well. So first case today, client who is a native and citizen of Kyrgyzstan. She entered the U.S. in 2013 with a J-1 visa. She was not subject to the 2-year home residency requirement, but when her program ended, she did not leave the country. Instead, she filed for asylum a few months later, which was still within a year of her entering the country. Her case was eventually referred to the immigration court, where it remained, and then she got married to a U.S. citizen in 2018. He filed for I-130 petition for her, and she wanted to file for her green card, but while the case was pending, and what they were doing a lot at this time in 2018 was that they put her case on the status docket. What that means is that you don't have a future court date. You have a date that you have to report. So it's not like a closure, or an admin closure, where you don't have a future court date, but you're still in court proceedings. You're still in court proceedings. You don't technically have a future court date, but you have a future report date. So it would say, like, if you have to report, by this date, and usually it was like a year, 2 years out, to the court. If you have an approval, you can tell the court, okay, my case was approved, now I'm ready to do the green card part, and you'd go before the judge back then. Or you would write and say, closer to the court date, we're still waiting for USCIS to approve. I need, more time. And then they'd send another status notice. So the nice thing about the status docket was that you didn't have to recalendar your case or reopen your case. It kind of just put you would go on the status docket because the judge was waiting for USCIS to take an action, and they take a long time sometimes to do things. So that's where her case had been sitting. So when her I-130 marriage petition was finally approved in 2021, like, awesome, now we can file the green card application and we can request dismissal, because by then they had already announced that they were going to be dismissing cases like that. So I filed a request for prosecutorial discretion back in October 2021, and that there was silence on DHS's part. And it was frustrating at the time because this was happening with a lot of our cases. There's still a lack of uniformity in the courts and how they're handling them, even the different judges. But they are starting to come, like I said, more frequently now. So after waiting, because they told us it could take a while, for like 6 months or something, I tracked down the DHS supervisor, and I sent an email directly to her, and I said, hey, we've been waiting on this for 6 months. What's going on here? Because they said, it's supposed to be decided in 30 days, and I had reached out after 30 days and no one answered. The next day, the supervisor wrote back that they're reviewing the case, and then the next day, another attorney, her subordinate, sent me a joint motion to dismiss, meaning they were approving our request for prosecutorial discretion. I signed it, I sent it to the judge, and then we just had to wait for the judge to sign off, which the judge did. So this client also, I should mention, has no criminal history, and as I said earlier, did enter with a visa. So those are all factors. They're not just looking at the approved I-130, they're looking at everything. And we had to show all of that and then explain all of that for them to agree to grant the prosecutorial discretion. And that's true of all these cases I'm going to mention today. So essentially, her case is now dismissed, and it goes back to USCIS, where they're either going to have a green card interview, or they could waive it and just approve her and give her a green card. How long that will take? Hopefully not long. So congratulations to client number 1. Client number 2 and 3 are mother and son. They are natives and citizens of Grenada. They entered the U.S. in 2014 with B2 visitor visas. In 2016, mom married a U.S. citizen, and her spouse filed an I-130 marriage petition for her. Unfortunately, in this case, I cannot wait to talk about one day when it's finally over. I'm not going to get into details, but he ended up being an abusive spouse, and he refused to go to the interview with her. It was rescheduled. There was all these issues, but she was a legitimate VAWA, or Violence Against Women Act, candidate, so we filed a VAWA with her. But she was unfortunate with her timing, because at the time we had a different president, and they used to never refer VAWA cases to court if the I-130 was denied. So I went with her to the interview, told the officer she's filing for VAWA, and they're supposed to give her time to file it, which they did, but she couldn't get a piece of it in 30 days. So they said, bring us a letter, we'll extend the time. So I did, yet they denied it anyway and put her in removal proceedings. So that was annoying, and she's been through a lot, this client. So this whole time, then COVID happened, basically. So her case kept getting pushed out. And they said for pending VAWA applications that they would approve them. Approve the request, the prosecutorial discretion request to terminate or admin close if you filed one. So we filed one, and again, client has no criminal history. She's VAWA, entered with the visa, same with her son, because it was a joint case. And DHS denied our motion to admin close or dismiss. So because the VAWA hadn't been approved yet, which again was really frustrating. And they kept kind of scheduling her back for court and telling us to file motions to continue, which wasn't fair, because we have no control over how long it takes USCIS to decide a VAWA petition. So we were just going to wait until the VAWA was approved. They literally told us, DHS, refile this when the VAWA is approved. So the plan was, that's what we'll do. As we're waiting, we get a notice with only like less than 2 weeks notice that her case was rescheduled for a hearing. And we were like, that's weird. So I go to the hearing, and it turns out that there was like 50 cases on, and they were all cases that DHS pre-approved for dismissal. And the question was, does your client want the case dismissed? And if your client wants the case dismissed, stay in the virtual room. If not, go ahead and leave. And that's when we also learned they will not close cases. They will only terminate, which is a big difference. Difference is closing, I mentioned earlier, you're still in removal proceedings, but no future court date. Terminate means no future court date, no removal proceedings. It matters if you have a work permit that's based on an application pending in court. Now, green cards are a little different, so you don't lose your work permit when it's terminated on that, but people who have asylum applications pending do have difficult decisions to make sometimes there. So I went to the hearing. I'm like, we've been trying to get this case dismissed. Of course we want it dismissed. And they finally dismissed it. So again, her case, her green card application and her sons are already filed. So it goes back to, well, now it goes to Vermont Service Center, where her VAWA is still pending. As soon as that's approved, it gets transferred to New York to the field office for either the green card interview or for approval, just approval. That's clients 2 and 3. Number 4, native and citizen of India. This one was interesting. This was a newer case for us. He came to us kind of later in the game. He actually had been put in removal proceedings because his I-751 was denied. And basically they canceled, which they're doing with a lot of people, canceled his hearing and sent to the attorney a scheduling order, basically saying, send us written pleadings and we'll schedule you for your final hearing. Well, his attorney did that, and the judge then said that she never got the response, so they ordered him removed in absentia, which means you failed to appear, basically, by not responding. So the other attorney filed a motion to reopen, a timely motion to reopen within the 30 days, and then that was denied because the other attorney didn't seek DHS's approval first. It was kind of a little nonsense because of course DHS would approve it. Why the judge would force it? The real reason is because it's not the judge who can grant prosecutorial discretion, it's DHS, so you have to get their approval. But the next case I'm going to talk about, I didn't seek DHS approval. I just filed a motion to terminate and it was granted. So as I said, it's very uneven. So he came to us, hired us, and I immediately contacted DHS. I explained to them everything that happened, that he was wrongly ordered removed. They showed proof that they submitted it. Then this motion got denied, and the judge even wrote, like, get DHS approval, resubmit. I did. So the next day, DHS was very quick. They sent me a joint motion to dismiss, and I then filed that with the court, and the judge quickly approved it. So again, another client, no criminal history, and his case is also back with USCIS for the pending I-751. If that gets denied again, then we go back. We have, like a lot of these clients, we'd end up back in court. But we think he has a very strong case, a very strong waiver case based on extreme hardship. So that's another one down the road that I look forward to talking about again. That's client 4. Almost done here. Client number 5 is a native of Guyana and a citizen of St. Lucia. He entered the U.S. in 2004 as an H-4. That's a dependent of an H-1B. He was placed into removal proceedings in 2015 because he had been married to a U.S. citizen, got his 2-year green card, I-751 denied. He then got remarried in 2018. That spouse then filed for him. And in 2019, they had filed the green card application too, even though they couldn't file it with USCIS because he was in removal proceedings. So they went to the interview and they approved the I-130, but they said, we have to close your I-485. We can't approve it because you're in removal proceedings. So we were so then when he came and hired us, basically, we filed a motion to terminate because that was right after they announced they were going to terminate cases. And, in this case, I had sent a few prosecutorial discretion requests to DHS. They hadn't responded. I was getting frustrated. So I had heard from colleagues, just send a motion to terminate. So I sent a motion to terminate, and the judge signed off. So his case is terminated. And again, he's now waiting for So his old recard application should actually be reopened now, and he's either going to have an interview or they will hopefully grant it without an interview. Our final case today happened today, and this one was strange in that I did not know this case. This case last time I was in court was 2019 with this client. He filed for asylum. So native and citizen in Nigeria, entered the US 2018, B2 visa, applied for asylum within a year. Case was referred to the court in 2019. He hired us then, and we went to the hearing. They scheduled him for a individual or merits hearing in 2024. That was before COVID, how far the backlog was for some judges. So, I gave him a nice long list of evidence. Like I said, give it to me anytime, but let's try to touch base at least a year in advance and get me what we need so we could start getting prepared. And then a week and a half ago, I get an email from the trial attorney from DHS in the case asking me if telling me my client's case was scheduled for today for an individual hearing, and that was asking if my client wanted to have his case dismissed. Now, I was like, wait, I didn't get a hearing notice. What do you mean there's a case on today or on the 21st? And I looked it up, and it had updated in the computer system, but that's not the official legal notice. It's the mailed notice. And they ended up not even mailing the notice out until June 14th to tell me I did court today, even though they didn't know if I was even available. So a little annoying, a little frustrating. And we told the client, we called them up and we said, hey, your case was moved up. What do you want to do? Do you want to go? We don't have time to submit any evidence with this little notice. We don't think you should go forward without other evidence. And we didn't file the asylum claim. It really had, unfortunately, a lot of weaknesses that we were trying to address with the evidence, but we didn't know if we could address it. And I will mention he did file his asylum without the help of a lawyer. So I was really, really stressed about this one because I was like, what if they don't continue the case? Because he tells us he wants to go forward. This was a client worried about losing his work permit. Because that, in his case, having his case dismissed meant no more application pending. So he legitimately had that concern. But unfortunately, nothing we can do about that except to tell him, you're stuck between a rock and a hard place, meaning, you don't have great options. Either you stay in removal proceedings and you risk the removal order because your case isn't that strong, or you get your case dismissed, you get to stay here, and maybe one day you find a nice U.S. citizen that you fall in love with and want to be with for the rest of your life, or you have a child who turns 21 who's a U.S. citizen that files for you, so you keep your eligibility, but no, you're not going to have your work permit. Or you go back to your country. And he was very reluctant at first, but then basically the judge tried to then tell us that notice was sent out to me in October of 2019, yet nobody had the notice, like it didn't exist. I didn't have it, DHS didn't have it, the judge didn't have it. She just had a notation that it was sent. So she's like, okay, well, obviously you don't have to go forward today, but obviously DHS can't promise this offer of dismissal will be on the table later on. And basically the judge told me the case was not a good case, which it's questionable how much the judge should have said about that. She was obviously pushing the client to dismiss, and she wasn't necessarily wrong, but she also didn't know the whole case. We hadn't had a chance to actually submit all of our evidence. So, we were on the fence, but we said to our client, it's your choice. They had slotted an hour and a half, so I had time to call the client, pause the hearing, talk to him, and basically, after the judge said to him, I don't think you have a good case, he realized, all right, I'd rather have my case dismissed than face this judge who's not going to grant my case, which we thought was, in his case, a good move. by the way, if something changes, he can always refile for asylum. Or basically ask his case. It is considered a refiling, I guess. But if it's on the same ground, you can show he initially filed within a year. So if it turns out his claim is viable or is now viable, because sometimes there's all sorts of reasons why a claim isn't viable. Sometimes a country conditions, if there's a way, if something changes, you don't lose your ability to have your claim heard at least. So his case was dismissed this morning, and he's the only client that isn't going back to USCIS and waiting for a green card or an interview. But he is going to be in the same situation as a lot of people who don't have really strong cases to get relief from removal or path to a legal status, but they do get to remain here. And then if it's better than having a deportation order, if down the line they are able to become eligible for relief in some other fashion, they'll be able to then apply, and it's much easier to apply when you're not in removal proceedings. So I packed a lot into this. I don't even know how long this has been. It's 21 plus minutes, 6 different cases. Well, 5 different cases technically, but 6 different clients. One of the cases kind of are the same. And 6 cases that were dismissed for all sorts of reasons and in different ways. We're hoping that the government starts to make it more uniform across the offices in the country, and at least internally, like in the New York City offices. If the procedure is the same, it's more helpful. But our number one goal, though, of course, is to get the case dismissed for our clients. And when that happens, we feel that we have a victory, even though every single one of these cases, except maybe the last one too one day, I do hope to be able to come back on here and tell you what ended up happening in all these cases. And my gut tells me that I'm going to be able to tell you all these clients who have green cards, because their cases wouldn't have been dismissed if they didn't have strong cases to begin with USCIS. Again, the last case was a little different category. So that was a lot to squeeze in here, but I thought it was interesting to be able to talk about different cases getting dismissed or reopened and dismissed in a short period of time for different reasons, to give all of you out there an idea of really what is going on with this prosecutorial discretion, this Doyle memo you may have heard about, with the courts, with all the backlogs. This is what they're doing. They're tweaking it along the way of how it's done, and sometimes you have to be ready to do it in a different way or do extra work to get the same results that you just got for someone. Like when something works, I then try it again, and then all of a sudden it doesn't work, so I have to do it a different way. But that's my job, to figure out how to get these cases approved, or just in these cases, just the approvals of dismissal. And we have a bunch of happy clients, and so that makes me very happy. And hopefully I'll be able to come back on soon to talk about a lot more dismissals. So that is all today for notable approvals. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you're watching. Hit that share button if you found this to be helpful or know someone who would. And if you need a lawyer, we are here for you. Our contact information on Facebook and YouTube, scrolling across the bottom of the screen. If you're watching on Instagram, go to our bio page and you will find our contact information there. And we hope to hear from you and be able to help you and your family. Thank you all for watching, and have a great day.